Good evening, everyone. Welcome to the National Spine and Pain Center's webinar. We will begin the webinar in just a few minutes to give additional people time to log in. Again, welcome to the National Spine and Pain Center's webinar series. We will begin in just a minute. For those of you just logging on, welcome to the National Spine and Pain Center's webinar series. We are so excited that you've joined us tonight. We are going to give about another minute for additional people to have time to log on. Again, thank you for joining us tonight. We will start in just 1 minute. Good evening. For those of you logging in, thank you for joining us tonight for the National Spine and Pain Center's webinar series. We will begin in just another 30 seconds to allow a few additional people time to log on. Again, thank you for joining us tonight. We'll start in just about 30 seconds. Good evening, everyone. For those of you just joining us, welcome to the National Spine and Pain Center's webinar series. We will start in just about another 2 to 3 seconds to allow some additional people time to log on. Again, welcome to the National Spine and Pain Center's webinar series. We will start in just a few seconds. Okay, good evening, everyone. Welcome to the National Spine and Pain Center's webinar series. I'd like to introduce Dr. Peter Stotz and launch the webinar off with all of you. Again, thank you for joining us. Dr. Stotz, take it away.
Great. Well, thank you, Michelle. It's a pleasure to be back here with you for the fourth installment of our clinical development series that really is intended to improve how all of the providers think about the practice of medicine and how we're caring for patients. This webinar is a little bit unique in that we are really diving into risk management. And what I think about when I start to think about what is quality care was actually a slide that Eric Grigsby put up once. And he and I did a webinar once, or a course once together, where we thought about the triangle of care. And when you're out there providing your quality care, you got to be able to provide the quality care at the top of the triangle. You have to get paid for the work that we do. And then you have to mitigate the risks of the care that we give. And the optimal care is going to be somewhere within this triangle. And everybody, I think, thinks about things a little bit different. Some people will say, look, I need to provide just the most cutting edge care up here. And they don't care if they get paid, or they don't care if they're doing things that are risky. And that's not wise, because eventually you'll get sued, or you'll have some kind of compliance problem. The other problem that you'll have is you won't get paid for the work that you're doing. So we need to have a concentration on administration and work. And so today's conference, today's discussion is really on the bottom half of this triangle. It is, what are our processes to help us run an efficient practice, and how do we do risk mitigation? On a future conference, we'll come back and we'll talk about quality care and ways to improve the care of any particular aspect of what you're doing in your practice. But today we're going to talk about risk mitigation mostly. On the first few courses that we've had actually 3. Doug Weiser and I spoke once. We had Kevin Miller and Mark Coleman 3 different times talking about our leadership within the organization and how we're looking at specific problems. Today, I've asked our co-COOs come to speak with us today and have that same little essential conversation or roundtable discussion with how we think about our care and how we're trying to deliver the most optimal care. I, a little naively as Chief Medical Officer, think doctors do doctor work, clinicians do clinician work, and all this other magic will happen. And so I'm actually really thrilled to have Greg and Catherine here today to talk to us about the magic and how they make it all happen behind the scenes, and how do we keep us out of trouble. So in a moment, we're going to jump into a longer term discussion with slides, et cetera, with Jen Sarter, our Vice President of Compliance, Judd Altman, our Associate Counsel in our practice, and Andy Vernick, one of our Defense Counsel that's been around for quite some time. You're not that old, Andy, but we're going to jump into that. But I thought we would just start with a brief conversation today, what we'll call an essential conversation with Catherine and Greg. I didn't, of course, I met Catherine when she came and worked with our practice at Premier Pain Centers up in New Jersey. And I initially got to meet Greg, and I heard about Greg from Andy, from Adam Sackstein, and saying, what a fantastic guy this Greg Tabo is. And so it's really kind of been a pleasure for me to get to know Greg and get to know Catherine even further. And I'm going to start with some questions for the two of you guys on just kind of how you're thinking about everything. So let's start with Greg. First of all, why don't you just tell us a little bit about yourself? You've been with the practice with the Prospera side initially for 5 years. Is that right?
I've been with Prospera since inception in 2000. I started with them in 2012. Came along with the partnership of National Pain Institute, one of the larger partnerships acquisitions in Florida. I've been in the pain space specific for 20 years now. I ran an intrathecal compounding lab for 7 years and met a lot of different physicians, practice groups, understood a lot of service lines throughout the pain space. And so since 2000, I've been only in the pain space and working, building, directing, operating, and growing interventional pain clinics. And so this has just been an opportunity to say, okay, now we're the largest and the best, and let's continue to grow it.
That's great. And Catherine, I've known you. You've been with Premier Pain Centers since you were 7, I think, right? And
about that, right?
So tell us a little bit about yourself and your background, and we'll get the other side of the group to meet our co-COO.
Excellent. Sure. So I've been with National Spine and Pain Centers about 5 years now. I've been in healthcare for about 25 years or so, but I've been in senior management positions, leadership positions for the last 20 years. My experience ranges from leadership positions within privately held companies, publicly traded, as well as private equity backed companies, all on the MSO side of things. So healthcare, it's in my blood, and love what I do and love interacting with our providers and with patients and our staff.
That's wonderful. And I only went to Greg first because on my screen, Greg is on top and Catherine is right below him on my screen. So I'm sure everybody's different, but there was no rhyme or reason there. But so Catherine, how's it been to work with Greg as he'd come on here?
It's been great. Honestly, it's been great. It's wonderful having a counterpart with incredible enthusiasm and energy. I think it's frightening. We think alike. I think Adam Sackstein would be a good person to ask, since he's had the opportunity to work with both of us. But it's been great. I have taken so many best practice ideas from Greg and have looked at opportunities, picked his brain, how to implement into our offices as well. So I would say all in all, it's been fun. It's been wonderful having somebody that can share experiences and help me out of jams. All in all, I'd say it's been—
Share the pain, per se?
Yes, exactly.
Get it?
Right.
Dad joke. That's what my kids call a dad joke.
It works.
So Greg, let's dive into that a little bit deeper. What are some of the areas that the merger of the two groups has added something to the sum being greater than the various parts? What are your thoughts, Greg?
Sure. I think at first, to echo what Catherine says, man, there is enough energy when Catherine and I are conjuring our days up that we should bottle it per se based on other conversation. But it's just we're both excited about the opportunity. We start looking at what are we currently doing, and what does our future look like, and how do we get there through different measurements. Some of the big ticket items that we talk about, some things that have been great for on some of the Prospera side physicians that may have not experienced the access to training as readily as it's available. For example, this weekend, Dr. Mangle and some others will be flying to Florida to host a cadaver course. Within, I want to say, in under 1 day, the cadaver course filled. I have doctors coming, a new doctor that joined us coming from Georgia. So the response of, hey, we want to be able to provide these services, but almost we didn't have this outlet, this turnkey, pick up the phone and outlet. Yeah, Medtronics and other people can provide you cadaver courses, but this goes a lot further. We're part of a large family where we can impact the care for our patient population by having doctors just, show up. I mean, we're taking weekends away, but it's just the excitement of Dr. Mangle and Doug and Mark and Coleman. But, Catherine's been intricate in making everyone available and sort of coordinating this. And it's, there's a nice buzz around that. One of the other, two other things, and Catherine, I'll let her elaborate, but we have a central fill pharmacy in Florida where we do certain things already. And Catherine's taken that and started integrating that into some of the other regions. And yeah, it's not perfect. And there's tons of room for improvement. And, we as leaders have to accept that we're going to have tough conversations to get us to a better place. And so to anyone on the call, that's what we're here for. We're here to make sure that this is the best place for everyone to practice medicine, for our patients to receive care, and our teams to work, period.
Yeah, that's great. I mean, as Doug said before, and I really like the idea, it's about the patient first. And when you're a small practitioner, you can recognize your employees. You can do things to try to say, hey, gee, thanks, thank you for all the hard work that you've done. Sometimes we can lose touch with how important our staff are, which is really a reflection of us on our patients. So it's really important that we keep our staff recognized. So Catherine, you had some thoughts on that, and what's the importance of what the COO does in trying to recognize our team members.
Yeah, absolutely. And especially, a lot of offices have, faced reductions at the staffing level as a result of COVID and the pandemic. And it's been very stressful for a lot of the center teams. But we've also seen the very best in our staff and our providers. And often what I hear from people is, how do I go about recognizing this outstanding performance, great attitude, teamwork, people pulling together? And I would just like to take a moment to remind people that we do have a program set up. It is called a STAR award system, and there's an easy email address that you can send a quick email to whenever you witness excellent performance or people working hard together despite incredible challenges. And it's starawards@treatingpain.com. And the operations team will work closely with our HR team. And there's a pin, there's a certificate, and wherever practical, the directors or the regional leadership deliver that in person. And we try to make a big deal of it. Again, we know that people are overcoming some significant challenges and concerns as we go into this new phase of increased COVID cases and such. But we see people doing remarkable things. We see staff pulling together. We see staff looking out for one another and looking out for patients. And we just want everybody to know there is a program out there that will recognize and support any of the accolades that people wish to give their staff or point out. Since we can't be everywhere at all times.
That's great. So Greg, pull back the shades for us and tell us what's happening behind the scenes from the operations perspective. How do you make all this magic work?
Sure. You know, on a day-to-day basis, I think, you know, the consolidation of vendors, the rollout of different reporting structures that both companies offer to facilitate for the providers, the visibility into the business, the visibility into, you know, we're tracking, you know, MMEs, we're heavy on the lab compliance adherence reports. We're heavy on, making sure the schedule optimization. You know, we talk about, you know, the opportunities to be able to provide some relief for the staff that have gone through a lot as, you know, as essential workers. You know, when we say essential, it's, you know, for the most part, and Catherine, on your side too, we've kept our facilities open, you know, through 9 months or 8 months of a pandemic. And we've done that by the quality of making sure that we had PPE supplies. If there's offices or anyone feels that we haven't done as good of a job, let Catherine or I know, because it's something, it's what our responsibility is. Other things behind the scenes are around, you know, pricing and contract negotiations around supply costs. You know, as we've watched our business get hit over the past few months and sustain itself, but take a hit, we now have the ability as a larger entity to consolidate some supply costs, which, you know, we have a team of people to do that. We are starting to collect, outcomes data on a larger scale to be able to go back to payers. You know, when's the last time a payer said to us that we're getting an increase in a rate? Okay. It's just, it doesn't happen. It's, you know, I don't want to age myself, but Medicare never used to be the baseline. And that's what we look at now. And so we start looking at, hey, look at everything that our 150, 180 doctors or providers are actually doing to impact healthcare. And how can we leverage that with the payers to say we can reduce expenses over the long term by providing higher quality outcomes? So those are just some of the things off the top that we take a look on a day-to-day basis, you know, whether it's the compliance reports, whether it's authorization reports and daily outputs. We want to keep our finger on the pulse, but we want to make sure that our local teams, where Catherine and I can't be all the time, but our local teams have their finger available for everyone as well.
Yeah, you know, you brought up something that I just want to make sure everybody knows, and it's not fallen off my radar. It's really by the nature of the various presentations that were given. Asaf Gordon has been working very hard on our outcomes, and we're going to have him come back at probably the next one if he can make it, and talk a little bit more like we're having this conversation right now about his thoughts and outcomes. And Ricardo Vallejo's been talking about research and how do we integrate those kind of things. And so we're going to continue these essential discussions on some real interesting topics of how we actually achieve some of those things that you just mentioned. So for the uninitiated or the initiated, who wants to bite off some of the synergies that we've actually created? Look, you know, when we merged, we were two very large practices, and the idea was, okay, we're going to have one CEO. All right, so we've got one CEO salary, and Kevin moved over to chairman of the board and that aspect of things. What are some of the practical synergies that you see? Okay, look, we're bringing in this to this center and this to this center, and how are we making the whole better in that way?
Yeah, I'll jump in first, and Greg, of course, add some additional color. But I would think, you know, right off the top is working with Greg and securing licenses for all of our states or most of our states to be able to participate in the mail order, the work comp mail order pharmacy. Also to be able to participate in the intrathecal pump refill program that Greg worked so hard to establish with Prospera. And so far we have launched Virginia and New Jersey. We're working on licenses for Illinois, Maryland, North Carolina, Connecticut, New York, basically everywhere, wherever our footprint is. And so those launched, we're about 3.5, almost 4 weeks into going live in those states. And as Greg mentioned, initially, some of the growth and the change comes with a little bit of frustration, but overwhelmingly, I would say that it's been very much embraced. And it's wonderful to be able to take something that has been such a best practice for Prospera and introduce and give our offices that opportunity. Patients first, and this absolutely does meet the needs of our patients. We're able to get them the medications when they need them, delivered to their home in the case of the work comp mail order pharmacy. Pump meds, we've had greater reliability. We're continuing to expand the formulary. But overwhelmingly, as I look at the programs, specifically the couple that I mentioned, there is a great opportunity, as well as the labs. So some of the states, for example, Florida did not have access to a lab, and we were able to change that and begin that process to move them over to the existing lab that Greg has developed and give them the opportunity as well to offer that for their patients.
Greg, anything to add to there?
It's a lot. I ask the people on the call and others to bear with us as we adjust. We work for this team on this call. We're going to continue to press against some things that may have been the norm for the Prospera clinics and is outside the norm for NSPC. For example, we used to have a standard formulation list. We set our pharmacy aside. We have the highest quality control, and I can say it, out of any pharmacy in the US around intrathecals, but we have a limited selection. So we're expanding that selection because we just partnered with another 150 providers. So we have to grow with it, and it's going to take us a little time, but we're going to make it happen. And it's exciting. I mean, there's things that, we've done. There's things that, Catherine and her team between I know the Pronox, the K laser, there's, we sort of have to start prioritizing because we don't want to be okay. Catherine and I are definitely not the people that just want to do okay at something. And so we want to methodically make sure that we allocate our time to the things that can help the majorities and then work our way. But it doesn't mean we won't stop in the middle of our day to fix something at any location, whatever it is. So just exciting times for everyone. And hopefully we're impacting each of the providers day to day as we do this.
That's great. So, as you were talking, I was thinking about the television show, The Weakest Link. And it's really true that we're only as good as our weakest link. And so it's really great that you guys are so devoted to not only having the largest, but the best practice in the world. And I thank you guys for all the hard work that you guys are doing, and make sure there is no weakest link. And I'll turn it over to, Catherine and Greg both, if you wanted to make a last minute 30-second comment, and then we're going to get on to some other important topics.
Sure. So I would echo what Greg had said earlier, which is if you're experiencing issues and you have frustrations or you're not receiving what you need, reach out directly to us. We are certainly available. We live to problem solve, and I would just say the future looks very bright and exciting.
Greg?
It's very rare you get an opportunity to not only be part of the largest, but something where you're structuring to be sort of the highest standard in an industry. We all have a responsibility to it. We hold ourselves to that responsibility. It's a privilege to sort of expand the doors of what Prospera is to what NSPC is doing, and looking forward to really building something really special here. So I appreciate everyone's support over the last 60, 90 days through the transition. I've had a ton of supportive people on the NSPC side who have been absolutely amazing. So just want to say thank you to each one of you.
Well, thank you. Welcome aboard, Greg and Catherine. Thank you for your continued support. And I'm going to try to stop saying your side versus our side. I keep trying to stop it. And I'm going to just, we're going to have to figure out a new term for, COO South and COO North or something different. But the merger's done. We need to keep working on it. And we need to think of it as one side. Somebody had a slide that I just recently saw about the politics. The bird has a right wing and a left wing, but you need both wings to fly. So here we are. So need to continue to move it all forward. So with that, thank you guys. I'll see you in about an hour for our Q&A, should we have any. But I'm going to turn it over to Jen Sartar. Jen is our Vice President of Compliance and Credentialing. She is really smart. I got to interview Jen when she joined the company. I guess that was about 2 or 3 years ago now, right? Is that right, Jen?
And 2.5 years, yeah.
And Jen is a woman who has been doing it all. She's got this job and helps with the research and this. And tonight we've asked her to talk about patients' access to their medical records, because there's some laws that recently changed that many of us don't know about. And this is actually part of the value of having a large organization is we have people like Jen who are really paying attention to the changing landscape of regulations and what we need to know and what we don't. And this is really important that you know this. So without any further ado, I'm going to turn it over to you, Jen.
Good evening, everyone. Thank you, Dr. Statz, and thank you everyone for the opportunity to talk to you today with my colleagues on these important issues, which may be, a little out of your wheelhouse, but like Dr. Statz said, my department is here to support you in these with these kinds of situations. I'm going to talk today about the patient's right of access to their medical records in a timely fashion. And essentially, we all know that under HIPAA, we are responsible for protecting PHI, protecting patients' personal health information. Recently, the government has, the Department of Health and Human Services in particular, has really started to stress the importance, in their view, of a patient being able to access their medical information quickly, smoothly, and without any impediments. And so you as providers and us as the people who support you have to live in this sweet spot between making sure that we are not a roadblock to getting patients the information they want and need, while still protecting that information when it's appropriate to do so. And it's not as easy as it sounds, but the government gives us a lot of boundaries in which we can operate. Under HIPAA, it is a component of HIPAA that patients have a right to timely production of their medical records. In general, we have about 30 days from the time that a patient requests, 30 calendar days from the time they request their records to produce them in the form that the patient has requested, as long as it's reasonable. There are exceptions to that, which I will get into, but in general, we have 30 days. Can I have the next slide, please? So as I was saying, recently, the Office for Civil Rights, which is a department within the Department of Health and Human Services, which oversees HIPAA and the enforcement of protection of personal health information, they have really put an emphasis on what they think of as being important, which is the timely production of medical records. And so in October 2019, the director of OCR, Roger Severino, gave an interview in which he announced that the patient's right to access medical records would be a focus of 2019 and 2020 reinforcement initiatives. And to show you what a switch this was, the OCR settled its very first case ever of right to access claims in September 2019. But since then, they have settled a total of 11 investigations as of today. So they went from none in just a little over a year to settling 11 investigations. He said this was going to be a priority, and he made it a priority. So these are some examples. In Bayfront State Health Petersburg, this was the very first case of the OCR settling a right to access complaint. They had to pay $85,000 to the OCR and adopt a corrective action plan because they did not provide a mother with timely access to records about her unborn child. In this situation, there were complications during the birth. The child had been monitored before birth and during birth, and it took the hospital over a year to produce those records for the mother. And that's just unacceptable. Another example is from Corunda Medical, which is a Florida-based company that provides primary care and IPM services to about 2,000 patients. And they had to pay OCR $85,000, adopt a corrective action plan, and possibly the worst part of this, they had to get involved in 1 year of monitoring from the OCR for failing to provide records to a third party as requested by the patient in a timely manner. If you're familiar with the Corporate Integrity Agreement, CIA, these OCR monitoring plans are the OCR's version of that. They're incredibly work intensive, time intensive. They cost a lot of money to engage in because of all the work and time that's spent responding to the monitoring program. So it's a big problem. Finally, a New York Spine and Medicine, which is a private medical practice specializing in neurology and pain management. And I think their offices are in Manhattan, obviously, in Miami Beach. And they had to pay $100,000 to the OCR, adopt a corrective action plan, and then get involved in 2 years of monitoring because they didn't provide a complete medical record set in a timely manner to a patient who requested it. In the case of New York Spine and Medicine, it was about a year for them to produce the complete record. In the case of Corunda Medical, it was really only about 3 months. So anything outside of that 30 days, if an extension is not properly requested, they're considering a possible corrective action is needed. Next slide, please. So what are the patient's rights to access under HIPAA? If you go to the Office of Civil Rights website, you will see all of the information that I'm going to talk about tonight. And you can click on healthcare privacy information and then go to information for individuals. And that website is plastered with the kind of graphics I'm showing you here. The OCR, everywhere you look, they've got, get your health information. It's powerful. Know what you need to know. They're really pushing patients to access that information. And they're very clear in their guidance on patients' rights. So patients have a right to get copies, in most cases in the manner the patient requests, as long as it's a reasonable request, including via email. If they request it by unsecured email, we can send it by unsecured. They have a right to receive records within 30 days of a request, like I was saying. They can be charged a reasonable fee for the supplies and labor used to prepare the records, but they cannot be denied access to their records because they have an outstanding balance or they haven't paid a bill. And we cannot say you have to pay the fees for record retrieval up front. We have to give them their records and then charge them the fee. If the patient has any issues with the contents, they do have a right to contest them. At NSPC, we have a form that patients can fill out that is HIPAA compliant, where they would indicate what their issue is with their medical record. We would turn that form over to you as a provider. You have the right to disagree in writing, to not accept their amendment. The writing has certain constraints, and again, this is something that we would help you with. But then the patient can respond to your refusal and ask that the disagreement, as they stated it, be noted and added to their record. And I've been through this with some of our providers, so if you've been through this before, you know what I'm talking about. The patient can request that health information be shared directly with others, such as family members. They have to request it in writing. And the patient has a right to file a complaint with the Office for Civil Rights if he or she feels their rights have been violated. Next slide, please. So what personal health information do individuals have a right under HIPAA to access? This is where we get into the idea of what we refer to as the designated record set. The designated record set includes medical records, billing records, payment and claims records, health plan enrollment records, case management records, and any other records that you as providers would use to make decisions about that individual. They don't have a right to access PHI about them that is not part of the designated record set. And the way we know the difference is because it's not used to make decisions about that individual patient. So these include any kind of healthcare operations assessments, quality assessments, peer review, patient safety activity records, or anything to do with business planning or management. They don't have access to that as part of their medical record. If this doesn't really apply to us, but they don't have the right to access psychotherapy notes, those are held under a whole separate house of rules. They also don't have a right to access information about the individual that's compiled in reasonable anticipation of or for use in a legal proceeding. So interestingly, they have a right to be aware of the PHI that's involved in the preparation of the legal proceeding or in the psychotherapy notes, but they don't have access to those actual notes or legal proceedings themselves. Next slide, please. Under what circumstances may a covered entity deny an individual's request for access to their PHI? As I just said, if it's not part of the designated record set, if it constitutes psychotherapy notes, or if it will be used in a legal proceeding. In addition, and this is a really interesting point, the OCR is very specific to say that this is in rare circumstances when a healthcare provider determines through professional judgment that the access requested is reasonably likely to endanger the life or safety of the individual or another person. And they make a distinction between reasonably likely and reasonably possible. So as a healthcare provider, you have to really feel in your professional judgment that providing that information is likely to put someone or that patient in danger. If we are denying a patient's access to their PHI, we must provide a denial in writing to the individual no later than 30 calendar days from the day of the request. And of course, they have the right to request a review, file a complaint with OCR, etc. Next slide, please. How timely must a covered entity be in responding to individuals' requests for access to their PHI? Basically, under HIPAA, we have 30 calendar days from the request. If we cannot respond and need more than 30 calendar days to produce the records, we can have an additional 30 calendar days, but we must provide the individual in writing and within that first 30-day period, a written statement why we cannot provide the records within 30 days and an estimated date of when we will be able to provide the records, and it has to be within 60 days. Next slide, please. Do individuals have a right under HIPAA to get copies of their x-rays or other diagnostic images? And if so, in what format? Yes, they do. That would be part of the designated record set. It's used to make decisions about the individual. And if they request a reasonable format in which we need to provide it to them, then it's incumbent upon us to do so. File sizes for some of these images can be large, and so HIPAA allows for some workaround there, but essentially, if they ask for it in a reasonable manner, we need to provide it in that manner. Next slide. Under HIPAA, when can a family member of an individual access the individual's PHI? I'm sure this comes up quite often. So first things first, the HIPAA privacy rule gives right to access to an individual's personal representative. It defined as someone authorized under state or applicable law to act on behalf of the individual with respect to healthcare decisions. So anyone authorized under state law to act on behalf of that individual pertaining to healthcare can access their PHI. An individual can direct a covered entity to provide PHI to a family member. The request must be in writing, signed by the individual, and clearly identifying the designated person and where the records should be sent. Sounds like any other kind of authorization. It's interesting when the individual is incapacitated, it's really left up to the professional judgment of the provider whether PHI or personal health information is shared with that individual's family. If the covered entity provider determines that it's in the best interest of the individual to disclose that information and the individual is not able to authorize, then you are able under HIPAA to provide that information. Same with a deceased individual. If a deceased individual's wife comes into the office and she wants the PHI of her husband, as long as the husband has not expressly told you that he doesn't want his wife having that information, it's okay to go ahead and disclose that information. Next slide, please. If someone has a healthcare power of attorney for an individual, can they obtain access to that individual's medical record? The answer is yes. However, when a physician reasonably believes that an individual has been or may be subjected to domestic violence, abuse, or neglect by the personal representative, or that treating a person as an individual's personal representative could endanger that individual, you can choose not to treat that person as the individual's personal representative and not to share their medical records. Again, you'd want to document all of this, your reasons for that decision, but you do have that capability if you feel that it would put the individual in danger. Next slide, please. What does the HIPAA privacy rule say about a research participant's right of access to research records or results? I included this because we are growing a research program and some of you may be involved in research or wanting to be involved in research. Much like psychotherapy notes, research is its own beast. It has its own HIPAA rules that it needs to follow, but generally it is a permitted exception for right to access when a patient is in a clinical trial. So in other words, they do not have access to their PHI when they're in a clinical trial. Their rights are suspended. But the research participant has to be made aware of that when they're consenting to the trial, and they have to agree to it. And then when the trial is over, their right to access that information is reinstated. So it's just a suspension of their right to access because of the research situation. Next slide, please. Next slide, please. Thank you. I think you have to go back one. Okay, go forward, please. Thank you. Sorry. If patients request copies of their medical records as permitted by the privacy rule, are they required to pay for the copies? As I said, we can charge a reasonable cost-based fee. My office can help you determine what that is if you're providing the records yourself. If the patient has agreed to receive a summary or explanation of the PHI rather than the actual medical record, you can also charge for the preparation of that. We can't include costs associated with researching and retrieving the requested information. Next slide, please. Can a healthcare provider withhold a copy of an individual's PHI because the covered entity wants to apply their payment for the records retrieval to an outstanding bill, or they have an outstanding bill? I talked about this earlier. We simply can't. We can't hold that over anyone who's trying to access their medical records. OCR would see that as us putting up roadblocks, and that's not the reputation we want to have. That would not make them happy. Next slide, please. Can an individual be charged a fee if the individual requests only to inspect her PHI at the covered entity? So this was interesting to me too. The covered entity, if an individual doesn't want a copy, but she wants to look at her records, that individual has the right to do that with respect to the designated record set. And it's our responsibility to arrange with the individual for a convenient time and place for her to inspect the medical records. And we can't charge an individual who takes notes, uses a smartphone to take pictures, or uses other personal resources to capture the information in the designated record set. My big caveat here, my big caution would be, if you have a patient who sits down with you to inspect their designated record set, it's very important that we make sure that they are only seeing their own PHI. Obviously, we would want to make sure that there would be no way to access any other PHI. Next slide, please. Does the individual have a right to access PHI about themselves maintained by a covered entity that is very old or archived? Yes. If we have PHI, whether it's archived or stored off-site or it's on paper, OCR doesn't care. They have a right to that information. HIPAA requires that we keep records. We keep records at NSPC back about 10 years, and we would be required to produce all of those. Next slide. So I just want to remind everyone that my office, exists to support you in this. We are happy to answer any questions as these situations come up. And I encourage you to reach out. Happy to help anytime. And thank you for your time tonight.
Thanks, Jen. I have a quick question for you and a comment for the group here. Let's just start with the question. I thought that the rules had just changed with patients having access to their information really at any time. How has it changed recently? What are the changes that you saw happen in the last 2-3 years?
So they've just really put a stress on us not acting as a roadblock to patients getting their information. They really don't want to see, like I said, it's a sweet spot. They really don't want to see a provider or a provider's office or an MSO making it difficult for patients to get their information. So we really have to navigate protecting information with this new push of, we want you to provide this information to the patient without giving them a hard time about it, and make it really easy for them.
And so here's where my comment comes in, and this kind of is a segue into Judd's presentation. But think about what you're writing in your notes, because if you write things like, patient's a pain in the ass, or I'm sorry, I shouldn't say those words since this is a recorded video. If you write things like this patient is a very difficult patient, think about how the patient is going to perceive that comment when they have the right to ask for their medical records. And the people who have more likely to ask for their medical records are people who may be considering suits and considering problems, and you don't want to establish that antagonism. So just the facts, please. If you want to say delightful lady, that's fine. But I stay away, steer clear of saying things that you'll regret at a later date. So I guess that goes without saying, but I thought I'd say it anyway.
I like it.
So thank you very much, Jen, and we'll see you in a few minutes if we have time at the end here, but perfect job. Thank you. I appreciate the the insight to what's happening here. Next is one of the next two people where you hope don't have to get to know, but both of them are a delight if you do have to get to know them. And it really comes down to understanding the legal processes, what's informed consent, how do we stay out of trouble, and then what do we do if we start to get it, you're concerned about things. Judd Altman is our associate counsel within National Spine and Pain Center, leads a lot of our efforts on these topics. Prior to joining National Spine and Pain, he was a defense counsel. I think, Judge, you told me for about 10 years before you joined our group here. So he's no novice to this whole field. And this is part of the cooperative agreement that we have to try to provide the optimal care, but recognizing there are issues out there. And Judd's going to help us stay out of trouble. Judd.
Thank you, Dr. Stats. And thank you to everyone who joined tonight. I am Judd Altman. I'm an associate counsel here at National Spine and Pain Centers. And just want to talk about the legal process and some informed consent considerations. So responding to the legal process is how I'm going to start. Just the objective, obviously our objective here is to provide world-class healthcare to our patients while at the same time protecting ourselves from unnecessary litigation or administrative actions. The strategy here is outreach by attorneys or patient requests for your participation in the legal process is a necessary part of the type of medicine you practice. However, there are best practices for dealing with the legal process that will ensure the least amount of disruption to your practice and the best outcomes. So there are different types of legal processes that you may receive. They can come in different forms, but essentially they fall into a couple different buckets. First one would be a subpoena for medical records. That's a legal document that would be sent to your office, may come to the physician's attention, it may come to the front office attention, but it's important to identify what the legal process or the legal request is seeking. Subpoenas for medical records can come in some different forms. Most of them that you will see will be titled subpoena for medical records. Some may say, from DC, they'll say a deposition for medical records, but you can avoid the deposition if you comply and provide us the medical records that we're requesting. The second type of legal process would be a subpoena for testimony. That would be either trial testimony or deposition testimony. And I included workers' compensation questionnaires in here because essentially when you are filling those out as the treating physician for a patient who is in the workers' compensation program, you're essentially testifying as to what you're writing down in the questionnaire. And the third type of legal process would be retained expert witness work. And that's obvious, I'll talk about that a little more later, but that would be outside of your bounds as a treating physician. You would be retained by an attorney for the patient or for somebody else to testify against the patient or for the physician. One thing I included on here is never call the attorney that issues the legal process unless you are told to proceed by NSPC legal. Now, with everything in law, there is, there are exceptions to this rule, and especially if you have a good relationship with an attorney or with your patient and the patient's attorney, you don't have to bring that to the NSPC legal. But what you shouldn't do is immediately get a subpoena and call the requesting attorney and start talking to them. So now responding to legal processes continued. We'll go through subpoenas for medical records first. These should be immediately provided to the center manager to be passed on to legal. We have a process in place such that we can provide those to outside providers to get the medical records. First, we have to make sure that these is a proper subpoena and for a proper patient, but we can get those turned around. So really there's not much that the physician or the mid-levels or the front office have to do in that case. But the important thing is that immediately upon receiving the subpoena for medical records, they should be provided to legal. There's a time period that we have to respond. And if we don't respond within that time period, it can get into some issues. The next section is subpoenas for testimony. I put in here, these are not suggestions or recommendations. They are orders of the court, even if signed by an attorney only. Ignore them at your own peril. If you get a subpoena to appear at trial, or if you get a subpoena to appear at a deposition at a time and place, those are orders of the court. And if you do not follow those orders, then you can be held in contempt. Trial testimony, this is a big one for providers. If you receive a subpoena for trial testimony, you can contact legal to set up a convenient date time for your testimony. We, as legal, will handle the outreach to the attorney who issued the subpoena. Now, with trial testimony, it's tough for them to actually give an exact time and exact date for your testimony. What we do is we try to narrow it down to a half a day, morning or afternoon, so that you don't have to cancel patients or cancel more patients than you need to. We try to do it for the least amount of disruption to your schedule. But again, this is an order of the court. And if you do not appear because it could interfere with your patient schedule, we can have issues. For deposition testimony, if you receive a request for a deposition, they can come in two forms: a notice of deposition or a subpoena for a deposition. Provide that information to your center manager. And this is where it gets into the iffy part. If it is a friendly deposition, a deposition from the attorney for your patient, you may contact the attorney and set up the deposition at your convenience. Be sure to provide the attorney with your fee schedule for depositions at that time. If you are provided any threatening letters regarding your availability and or the substance of your testimony, immediately provide that information to the legal team. Attorneys should not be acting that way. They should not be writing threatening letters to third parties who aren't involved in litigation. But there are some bad apples that can just kind of push the boundaries a little too far. And if that is the case, we are here to make sure we push them back in bounds and make sure that there's no nefarious things going on. I've had issues come up where there was essentially a letter threatening blackmail to a provider if they didn't testify a certain way. That's completely unprofessional and unethical. And we made sure we got outside counsel involved to make sure there was no more of those types of issues that came up through the deposition. This is definitely the exception as opposed to the rule. Most depositions that you will have to provide, we will not get outside counsel involved. They'll be fairly short depositions if you're a fact witness, which I'll go through later. And most attorneys are professional and only want to get some answers from you. So it's the odd issue where there's a threatening letter or a threatening email. And that should be brought to NSPC Legal's attention so that we can properly handle it. With regard to workers' compensation questionnaires, if you accepted the patient on the workers' comp program, you may have to fill out questionnaires regarding the plan of care and the current state of the patient. The issue here is that you want to make sure that if you are filling out this workers' comp questionnaire, the attorney that issued it they should give you a cover letter with it that says why they're issuing it and under what code section that you are required to respond to it. With regard to these questionnaires, you want to really stay within your wheelhouse. You want to put on there what you've seen and done and any opinions that you have and have formed about the patient's care that are within the area of expertise. You don't want to go out on a limb on any of these questionnaires and say something about the psychiatric care of the patient or the surgical care by an orthopedic surgeon or things like that. The easiest way is to answer the questions that are asked and stay within your area of expertise, and you shouldn't have follow-up issues. We've had some times in the past where workers' comp questionnaires were filled out and there was a subsequent deposition requested by the other side saying that they want to question the physician about certain answers on the questionnaire. The way to limit that is to recite facts from your care and treatment in those questionnaire responses, and don't go out on a limb with any opinions. Retained expert work. So if you've agreed to be an expert witness on behalf of a provider or a patient, you should provide your CV and fee schedule to the attorney prior to engaging to any work. And there should be some kind of written agreement between the attorney and you about what you're going to be doing, the scope of the work, and also your fees for the different parts of the work. And that should all be set out in a fee schedule. I've gotten a lot of questions about this since I joined NSPC about a year ago, and it's come up a lot in my previous life of being a litigator defending healthcare providers who are sued for malpractice. This is the fact witness versus an expert witness. And it may vary somewhat by jurisdiction, but this is the basics for the differences between a fact witness and an expert witness. So first to start out, an expert witness is anybody that a court says is an expert. You can go in front of a court and you can say, I'm Judd Altman, and they'll ask me some questions and they'll say, you're an expert in the law in this area of expertise. So you can be an expert witness as an MD, as a nurse practitioner, as a mid-level provider, as a nurse. You can be an expert witness in your area of expertise. But you should try to stay within the bounds of what you are being asked to do by the legal process. So you'll see on the left is the fact witness bubble. And there I just say in general, as a fact witness, you're only testifying about the facts of your care and treatment of the patient. This would be a subpoena for testimony, trial or deposition about the care that you actually provided to the patient. That includes the 5 W's. That's the best way to do it. Who, what, where, when, and why. And never give retrospective opinions. Retrospective is obviously looking backwards. If the question asks you to provide an opinion that you had not formed during the treatment of the patient, the best response at a trial or a deposition is, I have no opinion on that issue. We don't want you to, if you're being called as a fact witness, to start coming up with opinions at that point in time about the care that you provided that you didn't form during the care. So you're looking back at the care and trying to form opinions. That's a good way to get yourself into trouble when you're testifying. Now, if you move over to the expert witness portion, you'll see by agreement only. You can be both a fact and expert witness in a situation where you're a treating physician of a patient and that patient requests that you provide expert witness testimony. You fall into both categories. This would be a patient that got into a car accident and you treated them, and they want you to come testify as to what type of disability they'll have or if they need future medical treatment, things like that. If you're not a treating physician, but you are requested to review records and or examine the patient and provide an opinion, you're a pure expert witness. Back to the fact witness side. With fact witnesses, you are being compelled to provide the testimony by either a notice of deposition or a subpoena for deposition or a subpoena for a trial appearance. When that occurs, you are acting as a fact witness only. And that's all you will testify to is the facts of your treatment. Now, for expert witnesses, you are voluntarily appearing to provide your testimony pursuant to an agreement with counsel who's taking your deposition. Now, with regard to compensation, they're compensated very differently. If you are a fact witness, meaning that you're being compelled to provide testimony, be it deposition or trial testimony, in Virginia, you're technically only entitled to your travel expenses. But if you work with the attorney who is requesting the deposition, you can charge a reasonable rate for your time. I put a suggestion of $375 per hour. I think you could go up to close to $450, $500 an hour. Just be aware that if you make an unreasonable demand to an attorney, you say, sure, I'll come testify about my patient, but it'll cost you $1,500 an hour. Technically, that attorney can then go to the court and get an order compelling you to show up at the time and place of their choosing, and they'll only have to pay you reasonable travel expenses, which would be, I don't know, 55 cents a mile, and then if you have to pay for parking. So it's much better to try to work it out amicably with the counsel that has requested your deposition and getting a reasonable amount of for your time. And then even then we can schedule it at a time that won't disrupt your patient care such that you wouldn't necessarily be losing out on treating patients. With expert witnesses, the compensation is far more rich, and you can charge the requesting attorney the rate specified in your fee schedule. I said usually $1,000 an hour with a 3-hour minimum. That'd be for a deposition. That's a rate that I've seen a lot. And it's much easier to collect the high dollars for the expert witness care or the expert witness testimony than it is fact witness. Back in the fact witness category, you should make sure not to cross over into expert witness territory during your testimony. You do not want to be in a position where you are giving away your knowledge and experience for a reduced price. My example here would be that if you've been subpoenaed for a deposition and you start talking about the care and treatment of that patient, and then you get asked a question about a percentage of disability that the patient has moving forward. If during your care and treatment, you never endeavored to figure out what the disability is moving forward, but you decide at the deposition that you're going to give it a 30% partial disability. Well, you're stepping into expert witness territory there because you're opining to something retrospective that you didn't form during your care. And that's not necessarily a problem with that question. But once you start answering expert witness questions, it's hard to use my patented line of I have no opinion on that issue for a difficult question that may come 10, 15 questions down the line. So make sure that if you are a fact witness, if you're being compelled to give the testimony, that you stick to the facts, the who, what, where, when, and why, and don't get into extraneous opinions. With regard to expert witnesses, if you're a pure expert witness, so you're not treating the patient at issue, make sure to review all the pertinent records and data to support your opinions. I think this goes without saying, but you don't want to be made to look a fool at deposition. You are not only representing yourself, but you're representing, your profession and NSPC or the affiliate for NSPC. And make sure that you're prepared for those things. Prepared expert witnesses are the best to deal with. They're the most calm, cool, collected depositions, and things don't seem to go awry if the expert is prepared. So that's my spiel, for lack of a better term, on fact witnesses versus expert witnesses and the legal process with depositions and trial testimony. I wanted to touch on informed consent issues. I'll let Andy, talk about documentation issues in-depthly after me, but because of the increase in interventional pain procedures that we are instituting at, company-wide, that, hey, these things are new and they're the best techniques. Informed consent is a very difficult area to try to keep up with. It's good to know the ins and outs of informed consent and the documentation required for that informed consent. First thing I will tell you is that in the law, and this is especially in Virginia, informed consent is not a piece of paper that says informed consent at the top and that's signed by the patient. Informed consent is a process that the physician goes through with the patient to provide information and knowledge that the physician has that the patient doesn't have, in order for the patient to make an informed decision about whether they want to proceed with a procedure, about what the risks and benefits and alternative are to the procedure. The elements of informed consent are in this Bly versus Rhodes case. It's a Virginia case. It's the seminal case on informed consent for malpractice. One of the main features is it's a duty of the physician in the exercise of ordinary care to warn a patient of possible bad consequences of using a remedy, but that the failure to warn is not per se an act of negligence. Essentially, what's that saying is that in order to comply with the standard of care as a reasonably prudent physician in the same or similar circumstances, you have a duty to warn the patient of possible bad consequences of a procedure. The physician owes a duty to his patient to make reasonable disclosure of all significant facts under the circumstances of the then situation. I bolded that portion of this because if you take nothing else from my informed consent spiel, it's that you need to have reasonable disclosure of all significant facts under the circumstances. So here I can give you an example. If you're doing procedures, if you're giving pain injections to a patient, you don't need to tell them necessarily about, death that could occur from the injection. What you need to tell them are the reasonable, significant facts of the injection and the possible bad outcomes. That would be infection or bleeding or, punctured lung, things like that, that can occur more than a scintilla of the time. You don't need to tell them every single bad thing that can occur, but you do need to tell them what the major issues could be with the procedure. You also need to tell them the benefits of the procedure. Hey, this is what you should expect from doing this procedure. Temper their expectations. Patients believe that physicians are all-knowing and can have miracles and cure anything. Tempering expectations is a big part of informed consent. And then also alternatives are required to be provided. I think this gets lost in the shuffle sometimes, but patients need to be made aware that surgery isn't their only option. Conservative treatment could be an option. Doing nothing could be an option. If you don't believe that that is the best course of treatment, that's fair to say to the patient. We could do nothing, but in my opinion, that's not the best way to proceed. Is a perfect way to get to tell patient about other options. So here it says a physician is not required to disclose all risks possibly inherent in a particular treatment. Again, this goes to, they're not saying that you need to have a 3-day conversation with your patient before you give them an injection. You need to tell them the risks that are with the patient and risks with that certain procedure, and make sure that the patient is informed of what could occur. It also says, nor must a physician communicate information which the patient already knows or of which any reasonably intelligent person should be aware. This is saying, hey, you don't have to tell people that if you're giving them an injection that you're going to puncture their skin. A reasonably intelligent person would know that if they are getting an injection, it's going to puncture their skin. Also, if this is the 10th time that you've given injections to a patient, you don't necessarily need to go through the exact same informed consent procedure. But it's helpful to always do that on every occasion, even if it's happened 3 or 4 times previous. And another big issue here is to document the informed consent conversation in the medical record in your notes. It's not sufficient to merely have the informed consent form signed by the patient. There should be a notation in the medical record, towards the end of it, whenever it is, a conversation with the patient was had with regard to risks, benefits, alternatives to X procedure. Patient was permitted to ask questions. I answered questions for them, and they elected to proceed. They elected not to proceed, or they're going to think about it. Those all should be documented in the medical records. And again, here we're doing a little defensive documentation. Down the line, if somebody makes a claim against you saying they didn't tell me that I could, have a bleeding issue from this injections, not only will you have the signed paper as evidence, but they'll go back into the medical record and they'll see, hey, on this date, the date before the injections occurred, Dr. Altman wrote in his note, I had this conversation with the patient. We discussed X, Y, and Z. The patient consented to the procedure. It bolsters the evidence that you, in fact, informed the patient of everything that was required of you and were able to get the patient's informed consent. I have here a stem cell arts consent. This is a consent for aesthetic treatments. This is, I would say, a fairly comprehensive consent. One, it's not a general consent. It's a consent for aesthetic treatments that are specific to the performance of procedures. It goes through specific risks that are attended to the treatment at issue. That's how all consent should be framed. These general consents just will not stand up well in court. And you always want to be looking down the line to make sure that you have, covered your bases for any types of issues. This also is good to have because it is a document that you can go through with the patient and explain certain items to the patient. Patients will be hesitant to ask questions because they don't necessarily want to sound dumb in front of their physician. But if you're giving them something here, a piece of paper that has some terms on it, you can say, are you sure you understand this? Do you understand that? It's helpful in the informed consent process. I'll just reiterate what I said before. The increased procedures will require an increased documentation of the informed consent process. And it is really a process more so than just that form. And there needs to be documentation of the process that went through, and there really needs to be, tending to the patient's questions such that they feel they've made the decision on their own with the information that was provided to them by the expert, the physician that's caring for them or the mid-level provider. So those are all of my talking points for this one. I think it dovetails nicely into Andy's conversation about documentation. But other than that, I thank you for your time. You're muted, Dr. Stats.
Sorry, I just said something really important. No, I would just say, before we got on the call, Michelle guaranteed me that one of us would do that tonight, and I laughed. I said, I will be one of them. Judd, thanks very much. There are some questions, but for sake of time, we're going to turn it over to Andy and talk about how to document defensively. Andy is sitting in the courtroom of my cousin Vinny right now, and we were joking about that a little bit earlier too. And Andy's been our outside counsel. He's been a practicing defense attorney for 30 years and really knows his stuff. And there's an old saying that if you didn't document it, you didn't do it. So that's the medical side of longer presentation by Andy. So I'll turn it over to you, Andy.
Thank you. Let me move this here. It's not moving here. Bear with me 1 second. And just like Dr. Stats said, could you move to the next slide and I'll figure this out? Good morning, ladies and gentlemen of the court. My name is Andrew Vernick, and I represent the Smith family. Mr. Jeffrey Smith passed away on November 2nd, 2019. He didn't have to pass away. He left his children, 2 of them, and his wife. He will never come home and play ball with his son, and he will never walk his daughter down the aisle when she gets married. It did not have to be this way. The reason he passed away is because of the deficient care at National Spine and Pain Center through its physicians, its ancillary providers who you'll hear called physician's assistants and nurse practitioners. The staff at NSPC over-medicated Mr. Jeff Smith. They gave him too many opioids and it caused his death. You will see in the medical records of this organization that there was no documentation that reflected a consistent course of care about how Mr. Smith was doing trying to manage the pain that he came to NSPC for treatment. Literally, the records that reflect, and you will see them through this trial, that almost every visit had almost the same record. It is what you'll hear is an electronic medical record where literally the staff just copied the medical records basically and carried them over to the next visit. The records will reflect that he received too much pain medication. You'll hear the phrase opioids, which I'm sure you've heard before. The staff had 15-minute checks or office visits, and they moved on to the next patient. And when they moved on with Mr. Smith receiving too much medication, they moved him into a situation where he received too much medication and died. The result of this case is going to be clear to you. And at the end of this case, we will ask you to return a verdict for the Smith family. They'll never be able to get their father back, but hopefully you can provide them with some monetary relief. So if I can move to the next slide, let me make sure I can figure this out. Okay. My goal today is to talk to you about how to reduce the risk of getting sued and spending 2 years with somebody like me. Now, I realize that in the scheme of things, you know, my wife loves me, my dog runs to me, my kids come to me for money, but you don't want to be with a defense lawyer for several years. And so the reality of this is my goal and my job today is to give you some tidbits and some process to avoid or reduce the risk of doing this. And obviously I'm not doing a very good job as I can't even move this PowerPoint, but thank you. The first slide up here is not a joke, but I put it up here to give you an example of what you're not going to face. This is a case that was filed by a woman who got doinked, if you will, by a bingo board at a church that fell over and hit her. And she claimed that she thereafter had orgasms that came at random times and were causing her all kinds of problems. Putting all that aside, she retained a lawyer and a lawyer filed a lawsuit. I raised this with you, and if you can move to the next slide, the reality of what you're going to face is not a lawyer that has the ability to put $65 down. And that's all it takes to file a lawsuit. When you get sued as a medical provider, you are not going to be sued by the run-of-the-mill lawyer. You're not going to be sued by a lawyer that does random and run-of-the-mill auto torts. As Dorothy said in The Wizard of Oz, when you get sued as a medical provider, you're going to have the feeling that you have no idea what's going on, and you're certainly not in Kansas anymore. You're going to be dealing with the best lawyers because a very simple fact, money brings the best lawyers. When you have simple lawsuits, people can go out and drive a car and you have 20, 40, 10 coverage. $20,000 is all you have in some states. When you are sued when a healthcare provider is sued, most providers have about $1 million of coverage, if not more. So you bring much better lawyers to the table and they know exactly what they're doing. And if you could click to the next slide. You'll see this cartoon here. It's here as a little light, as levity on a Tuesday evening when I'm sure you all want to be someplace else. But you've got a lawyer here that asked the court for permission to slap his client, his witness, upside the head. The process of getting you ready, to getting you prepared to engage in a medical malpractice suit is not easy. It's not something that's enjoyable for you. I mean, the reality of it is you've probably all seen that questionnaire that where they ask people, what are they more fearful of, speaking in public or running naked in public? And a lot of people choose speaking in public. You're on the witness stand and you're not in your element. You're not providing medical care, and you've got a lawyer who knows exactly what he or she is doing, trying to make a fool out of you. And unfortunately, when you're not in your element, it creates opportunities for you to make mistakes that compound what we're going to talk about in a minute, as far as trying to avoid malpractice cases. If you click to the next slide. There are three basic things, and if you're going to write anything down today, I want you to write this down. There are three things that you're going to have to remember that are going to reduce your risk of being sued short of winning the lottery and not practicing anymore. The first one is documentation. Go to the second one. The second one is documentation, and you know what the third one's going to be. You guessed it, it's documentation. I can sit here and talk to you all day long about your techniques. I can sit here and talk about, you know, how you do your interaction with your patient. And I don't want to minimize bedside manner, because how you engage your patient, we could do a whole nother seminar on that, because it is true that your engagement with your patient and how you empathize with them, as opposed to, and I'm not saying you all do this, giving them the sense that they're on a conveyor belt, does matter. But we're not on that topic today. If we can go to the next slide. Documentation 101 is a very simple process. The takeaway that I want to talk to you about, and you can click through the next two. The reality of it is, you all can write your charts 99 times out of 100 or 999 out of whatever number it is, and nothing's going to happen. It's not going to be important, because nobody's going to have a bad result. Nobody's going to sue you. And even if you've made little hiccups in your care or you've not documented it well, it's not going to matter until you get sued. And then when you get sued, everything matters. And you can't imagine how embarrassed you're going to be when you're being dissected by a lawyer about what your record says or doesn't say. It is inch by inch dissection, and it's not pretty. And it makes you you're good providers, but when your record is what speaks for you, it makes you look like you're not a competent provider. And so, you know, I realize you all have 24 hours in the day, the same 24 hours that I do, but documentation is not something that should be put on the back burner, even though it's not likely to be a problem for you, but when it is, it's colossal. So if we could switch to the next slide. And here's something I want to make sure you understand with an exclamation mark, and I should have highlighted this. If you get a whisper, a whiff, or whatever it is that you are going to be sued, or somebody threatens you with a suit, or somebody walks out and they're pissed off at you, or sends you a letter and you forward it on to Judd about they're thinking about suing you, do not think, do not touch, do not walk by, do not have somebody else walk by the record. Do not think about changing it. Don't dream about changing it. Leave the record alone. Because the reality of it is, in this day and age, with the EMR systems that we'll talk about, a plaintiff's lawyer will be able to know if you went back in and what you did to that record. And therefore, what could be and would be a defensible case. Yeah, there might be some warts on the record, and there might be some things we have to explain. But if you touch that record, if you alter that record, you have turned a case that could be defended into an indefensible case. So the reality of it is, if you have a recollection afterwards, you add it verbally in a deposition. You say, I wrote this on that date, but I do remember X, Y, and Z. If you're going to make an addition to the note or thinking about doing that, the first thing in your mind is don't. The second thing you do is call Judd and tell him what's going on. And then you'll sort of be put at ease if that's not something you want to do. So if we go to the next slide, thank you. And click in the first animation. What I want to chat with you about are some obvious things. Some of these apply here and some of them don't, but I want to give you a perspective on how some people have dealt with documentation, and some of them are funny, some of them are sad, but the reality of it is, it gives you a perspective on how sometimes people document that you just have to scratch your head and say, this is crazy, but it happens, so that even step downs from this that are not as radically adverse to reality can also get you into trouble. But the first thing is you need to document contemporaneous. And what I mean by that is if you go a day or if you go 2 days and you've seen 30 patients in that time frame, and then you generate your note, and a lawyer looks at that, it is likely that you're going to be subject to a lot of cross-examination based on the fact that how could you possibly have compiled this note unless, again, you carried everything over through the electronic medical record, because you did it a day later or 2 days later. And when you look at it, it's not just, it might be totally accurate, but you're opening yourself up to the cross-exam of how could you possibly know this? And the reality of it is it looks bad. It creates and reverberates the mill or the conveyor belt attitude that we don't want to convey, that we're just sliding patients in and we don't have time to document. So document contemporaneous and don't let it dawdle down the road. Next slide. This is something I put in here. I know you all use EMR, but I had to put it in here because not too far down the road, this is something that occurred 4 years ago. And if you can click the next slide, this is an actual medical record documented on magazine subscriptions. It's not only funny, but I guess what's sad is that somebody thought that this was a reasonable way to document. And it just, can you imagine going in front of a jury? And the reason I raise this with you is you're asking a jury to believe you. You're asking a jury who doesn't know you to go back in that voting booth jury room and say, I like this doctor. I would go to this doctor. And therefore, all these medical issues about them potentially violating the standard of care, I don't believe them. And if you start out with, in an opening statement, the plaintiff's lawyer puts this up and says, ladies and gentlemen, Dr. Smith over there, look at his notes. You've lost that credibility. And a jury is just by that note going to not have you in high regard. So documentation, how it looks, how it comes across does matter. Next slide. The other thing, and I think Dr. Statz mentioned it a moment ago, I think he mentioned only the facts. That's true. And if you click the next slide, this is a case that goes back a little bit, and I'm not sure if you can read it, so I'll read it to you. Let me pull this up. It says in the circle part, Dr. Blank did some extensive surgery on this lady, and there was no intraoperative or immediate postoperative problems, except she kept wanting to bleed a lot. We got her up to the floor, and she did not want to respond well. We called Dr. Blank in, took her to the ICU, and she stayed there for a few days and then died. Now, I mean, obviously, this is a true medical record. And it just goes to show you again, if you are an author of a record, this is a representation of you. It's a representation of the practice. It is what the jury sees, because remember, they're not your cul-de-sac mates in your neighborhood. They don't know you. They're going to get to know you, meaning the jury, based on how you testify and whether you're crying back at the counsel table with me, which hopefully won't happen, and your medical record. And so if your medical record is a poor reflection of you, that's a significant first impression that is going to be hard to get over, even if you testify well. So it is just the facts, and that's important. And so hopefully this kind of thing will stay in your brain, both the way the record looked on that prescription ordering for magazines and how this surgeon wrote this note. If you go to the next slide. I talk here about documentation vacations. There are cases that I have where there's an office visit billed for, but no medical record. Now, you know, you can come back and say, well, I saw the patient and it was really pretty much the same. I'm sure I wrote a note, but I don't know where it is. Or it probably just got discarded, or maybe it didn't get uploaded, or whatever it is. Hopefully that's the truth, as opposed to it just wasn't done because you were too busy and didn't get it done. But I just want to emphasize that it's not a rarity that there are documentation vacations, and that's just not acceptable. Next slide, please. Let me talk to you why documentation is such a big deal, and put the first two slides, the first two animations up, if you could, please. Lawsuits are filed, they can be filed within 3 years of the care or the injury. So if you think about it, if you go, how many patients might you see in a 3-year period? Could be 1,000 patients plus or minus here and there, but it's a massive number. So what is the likelihood that you remember a single patient 3 years ago in the mass of all of the patients, your life, your kids, your dog, your cat, and your goldfish, or whatever it is? It's highly unlikely, but this is a one and done for that patient. That patient's family remembers every time he or she came home, or the patient, if they're still with us, remembers everything. They remember how they got, or they'll testify, we got brushed off and we came in, they didn't spend time with us. We didn't feel like they answered our questions. They gave us pills and sent us on our way. They remember. And there's a reason why they remember, because that's their personal experience. But if you don't document, if you don't put it down in a record, and you come in with this massive recollection 3 years later, and if you could just pull up the last slide, or say you're sitting on a jury and you hear a provider coming in saying, oh yeah, 3 years, I remember Mr. Jones came in. Oh, I told him everything about that on July 6, 2015. You're gonna hurt your credibility. And remember, we've got two credibility wings here. We've got your records and you. And so if you come up with this miraculous recollection, and a good plaintiff's lawyer is gonna skewer you as to the reality of your created, found recollection, so that your credibility with that voting booth jury is going to be non-existent. So why is documentation a big deal? Because without it, you don't likely have a recollection. Because remember, your approach is, this wasn't an unusual patient. Because you're talking about a patient that's coming in and he's having, or she's having, whatever is going on. If it is going to be a big deal, if there are a lot of things going on, I would assume that you're bringing in, if you're being supervised by a doctor, they're helping out, or you're documenting, hopefully, a lot of things going on. But the problem is, most of the documentation that I see is pretty standard throughout all of these cases. And the cases that result in lawsuits aren't generally the patients that are your biggest problems. They could be the sleeper patients that are just going along, and you've not weaned them away from medications, you've not given them alternatives, and something happens. And there's no reason for you to have this stellar recollection because the patient wasn't standing out. But documentation is really your basic form of defense, in addition to your routines, because you're probably not going to have a big time recollection. If we go to the next slide and click the next one, please. A lot of what I'm going to say to you, you're probably sitting back there maybe with your glass of wine, or maybe you've turned on a TV behind you to watch that rather than me. And I get it. But what I'm going to chat with you about are things that need to go in the record, things that you have been trained to put in the record. But what I see when I get the record, they're not there. They're not there, even though you might have talked to the patient about the interval history. Now, I can live with, if it's not documented, not as well as the documentation of it, the following. I've got a routine. Every time a patient comes in, like I put my shoes on in the morning, assuming you wear shoes, I do the same thing with every patient, and I do an interval history, and I find out about their new problems since 30 days ago, any new pain, any side effects, any new meds, any new doctors, any new anything, and if there's a positive, I chart it. If there's a negative, I don't. A routine of that is a weak sister to a good chart. And so what I'm saying to you is a record should have that interval history documented in it. Next slide, please. A review of system is consistent with the interval history. And again, at a minimum, if you don't have check boxes, I know on the left-hand side of some of the EMR systems, there are reviews of systems. And all I would ask that you do is make an indication that that's new and not carried over from the prior visit when it's identical to what's on the prior visit and on the prior visit after that and the prior visit before that. So if all the reviews of systems are the same, there's no indication that you did it, and your statement that it's my routine to do it sometimes falls on deaf ears. So at least put in there what I said, review ROS, nothing new. So you've gone through it and you document it. Most of all of your charts have the current pain levels because it's from that you work. But one of the things that sometimes occurs in these cases is that you see a 7777 and it just carries all the way through it. So be mindful of how that looks. So when you're writing current pain level and you're seeing this repetitive 7 or 8 that sort of is like a broken record, every once in a while put in there, continue to ask patient about consistent pain level, still a 7. Something that jogs the record so that it looks new and isn't this carryover. Next slide, please. This is probably one of the, along with not stellar documentation of interval history, is what do you do with non-compliance? Somebody's short of pills, they come back and they've been without pills, and you do a UDS and they're negative on an opioid. And they say, I just ran out, or I lost a pill or something like that. It's usually I just ran out. Whatever it might be, these are the little red flags that need more than just a statement that they were short by 2 or 3 days or whatever. You need to put in there the outlier response, that you did something, that you responded to this, and that you counseled the patient. And if you got a UDS that's non-compliant, it's not just sitting in there as this naked record with no response, no discussion. Although I know you'd say, of course I raised it with the patient. Of course we discussed it. But again, you've got the patient who's sitting there on the witness stand. No way, didn't raise it at all. They said it was okay, just come back and here's some more. So, you need to fill out your records as if you're going to be sued on every record and you're good with it. And I realize that's asking you a lot. And I know that that's the aspirational goal. But if I can get you to do a couple things and to incorporate a couple of these things, then all of your records will be improved. But the last one here that I'd skipped over is alternative treatments and weaning of opioids. One of the things that is probably right up there with the non-compliance and what do you do with it is the MME issue. And I'm so tired of getting the Center for Disease Control or the CDC guideline that was meant for primary care or family practice physicians thrown at specialists like you all when they're talking about 90 MMEs being on the top of the mountain, and if you get near there, you should be drummed out of the business. But what happens is it is invariably the response that, of course, we talk to our patients about alternative treatments, and they denied that. They said they used them before and it didn't work, and we of course try to get them to the lowest level, but they were functioning at this level, and we really didn't feel it was appropriate to wean them, or it wasn't working. You need to have these continued discussions with the patients, and they need to be documented. If the alternative treatments are not working or haven't worked, try them again or reference them again. And the same thing as far as if you've talked to the patient about weaning or you've raised it with your supervising physician, there needs to be documentation of it. So, okay, next slide. These things keep, every time I turn around, there's another slide there. And I think this is what we were talking about earlier. It's as it relates to the medication and the compliance or non-compliance and alternative treatments and lowering the MME levels, that whatever you're going to do with opioids, changing them, going up, down, or changing the meds, you've got to have a reason for doing it. And so if you look at all of these 6 issues that I have raised here, these fit into the categories of the most often issues that are deficient or absent in a record. And you know, again, if we're talking about a 15-minute pain check or medication check, I get it. And as I've said to you, I'm preaching to you about an aspirational goal that in the everyday practice is hard and is in some cases not it's not something that's realistic to touch every single one of these bases, because you'd be writing, you'd be seeing a couple patients a day. And what I'm saying to you is look at these 6 things here. And if you can incorporate them, maybe not on every single visit, but if you can realize that you can sequentially bring them in, and as these are coming up on a recurrent basis with different patients, at least try to incorporate some of these concepts. Because if you don't, and you're sitting on the witness stand, and the best you've got is, I'm sure I raised it with them. That's my routine to have raised it with them. That's not nearly as strong if you're asking for a lay jury to rule in your favor than if you've documented it. Because as Dr. Stats said, if it ain't written, it ain't done. And that's a simple statement that you hear. Okay. This is something that you heard also, Dr. Stats was just chatting about, and these are real issues that I've had in cases. And if you can pull up the first one, there was a reference to drug seeking, and that might sound innocuous to you, but if you've got a person who's deceased, or a person who is going to be presented very sympathetically on a witness stand, and you are being accused of giving them drugs, you're being accused of not managing their drugs, and they're the victim, that statement is not going to sit well. So if the corollary, if you click in the next slide, is instead of saying something derogatory, just say, you know, patient has been seen in the ED 5 times over 3 months, et cetera, requesting medication. Put the facts down. Just put the facts, and that will convey what you're talking about, as opposed to calling them drug seeking. Next slide. Malingering shouldn't be used in your words, in your records. Just say there's no objective evidence for blank, whatever it might be. Next slide. Now, this is in a record relating to a patient who a pain provider puts this in there, and with a heavy female patient. And you know, the next slide obviously is the way you want to do that. But again, this patient passed away, and I don't care how good the care was. I don't care how good the rest of the record was. Can you imagine the disgust that a jury would have had, this case did not go to trial, with that one phrase when they looked at the provider that documented it? Just, you know, next slide. The basic takeaway is that you do not gain anything. You do not get rewards or stars or you know, a gift card to Starbucks if you use a funny phrase in a medical record and go show it to a friend or another a coworker. But you can lose the case on a mega heifer comment. So not worth it, doesn't get you anywhere, and just don't even think about it. Okay, next slide. I hate medical records, electronic medical records. I just, I don't like them. I used to love the fact that I knew where a medical record was. I could turn a chart and I could read it. Well, sometimes you could read provider handwritings, but at least you know what you were getting because it was right in front of you. The biggest problem I find with medical record issues when I sit down with a provider is that they didn't really know what happened with the system. And part of it could be maybe their training on the front side, whether they didn't get adequate training or didn't pay attention to it. The other part of it is the systems can be so complicated that the drop downs, the carryovers, the defaults are just staggering, and you can get yourself into a trip box and not realize what you clicked on and what that has done with the system. but the starting point with your system, and I, I would ask a question, but I don't know whether everybody's on the same system. But if you're not, or if you're coming from another company and you're just starting an SPC, you just have to take time to learn the system. It will be time well spent. Next one. The reason this is important, and you can't presume that whatever system you had worked on, had been trained on before, or that a cursory evaluation of the EMMA system is good enough, is that they are so sophisticated that the carryovers through the software and the auto populations and the defaults can create records that are not consistent with the actual care, but by the mistake of the auto-populated process or whatever, a entry has been carried over, or a finding has been carried over, or something is persistent when it wasn't. They didn't have it on this visit, but it got carried over. They didn't have that kind of pain, but it got carried over. You definitely talked to them and they told you they didn't have whatever it is, but it got carried over. And so you need to know the system for you to provide yourself with the best defense if you're ever going to be sued, because otherwise you could get there and you sit down with your lawyer and say, I didn't write that. That didn't happen. Or I never used that phrase, but it all got carried over and it's too late. Next slide, please. I'm probably somebody that if you could throw something at the screen now, not only have I told you all those 6 points that I want you to put in your medical record, and start writing a volume on each patient, but now I'm asking you not to pull over the prior note. What I'm going to say to you is, I understand the ease that comes from sort of pulling over historically some things from the prior note. But what you need to understand is that everything comes over, including the kitchen sink. And so what happens is there are little gems of the current visit that are in this gargantuan carried over data from, it could go back months or even years as far as the carryover. And again, I'm getting you back into the voting booth jury. The jury looks at this and the jury's perspective is, damn, they're so busy, they're just carrying over notes. And the patient says when they're suing, and the patient's testifying, they didn't have time for me. They just breezed me in and breezed me out. So this is a component of the optics that we're creating and giving to the plaintiff's attorney with a thank you note to sue us and go buy a Maserati, because we're making this too easy for them. I understand that there's a way you can pull over a note, but you've got to make sure that when you get to the end and you're looking at your note, and hopefully you have a chance to look at it, and as it's finalized, you make a decision about whether you want to get rid of things or you opt out of them as you pull over only certain things. But I realize that it's hard to start fresh with a note, and bringing over some historical things are fine. I just ask you to be a little bit more conscious of how a totally carried over note, with the only difference being the pain levels now 8 instead of 7, stands out as a hidden needle in a haystack. Next slide, please. Thank you. And this is what I was sort of just chatting with you about it. And one of the things that I ask you to do is, how would you feel if you were a jury looking at these facts coming back, looking at these records that really don't make sense because they've been carried over? You're not going to look at this if you're dispassionately evaluating the scenario, because again, all you have to be judged by is your recollection, which is likely to be pretty meager, and your records. And every day that you put together a deficient record, you're enhancing the potential that if you're sued, your outcome will not be favorable. Next slide. And this is what we chatted about a moment ago. If 3 years later, you can't use the record to support you, if the record is deficient, it's not good enough to present that you provide the standard of care, in the context of a situation that you don't recall, it's hard to win. It really is. Because remember, these lawyers are not suing for stubbed toes or ladies that get doinked by a bingo board. These lawyers are suing because they've got significant damages. And when you have significant damages, that brings along with it significant sympathy. And so you're fighting an uphill battle. And if you throw the records out and you don't have a significant recollection, good luck. Next slide. I put this in here, and I'm not sure if any of you can really see this, but this is what these plaintiffs' lawyers do. And this is a request from a plaintiff's lawyer to obtain metadata or an audit trail of all of the information that was behind this medical record. And the first page talks about the different systems, the CT, this was a radiology case, a CT PAC system and the different systems. And then if you can go to the next page, they're going through and they want the audit trail that talks about anybody who touched it, the credentials of them, their passwords, when they went into it, et cetera. And what I want you to take away from this is the reality that there's nothing you can hide in an EMR system. And by the HIPAA laws, we are obligated to maintain an audit trail. So we are laid open and bare to a plaintiff's attorney who pursues these inquiries, and they do. Almost every case I have with a sophisticated plaintiff's lawyer, they are going to get down to your shoe size. And if you hiccuped on that record, they'll know when you did and what you did. So if you say, oh, I went in and I did X, Y, and Z. I did the review of systems on that day. It was all the same. I just didn't chart it. They can find whether you ticked onto the review of systems. Now you may say, oh, I didn't go in there, but I did it on my own. You know, you're now starting to go down on a rabbit hole where your credibility is going to get dinged. So I tell you all of this, and I don't want you to be scared and go and think about becoming a truck driver. You are in a good profession. It's a laudable profession. It's a needed profession in light of our fallible bodies as humans. But you need to understand that what you write every day isn't just a Taco Bell drive-through event. It is important to you. It's important to NSPC, and it's important to me if I'm defending you. So that's my documentation lecture for the day. I want to touch one more thing that I'm seeing more and more of that is a problem. And delegation agreements for you physician's assistants and the doctors who are supervisors or the secondary supervisor. This is huge. These documents that you might have signed years ago are documents that are things that you cannot shy away from. You must understand that you are responsible for the accuracy of a delegation agreement that says you will be supervised, you are supervised, and if you do not comply with it, you can be brought up before the Board of Medicine. And if you're a doctor and you sign it, you are obligated to provide those services. You can't just say, oh, that PA is great, I don't need to worry about it. Next slide. And the thing about it is, don't assume, and we've had discussions with Judd and counsel at NSPC about trying to get a little bit of a backstop where there may be an opportunity to provide some kind of tickler or notice to you, but you cannot assume that NSPC is going to do that for you, either you as a doctor or the PAs. So if a doctor moves and they're no longer in your office, you can't continue to practice as a PA without a new provider agreement. And you can't assume that somebody else will do it for you. And next slide. The Board of Medicine, I practice in Maryland and DC and Delaware. The Board of Medicines in these jurisdictions are investigating all delegation agreements. There's something that's been passed back and forth between them because they believe that they've not been complied with, and they are pulling them like you're going through customs. So they might pull every third one or every 10th one, and you can be brought before the board. So let me give you my last slide and I'll let you go home. Well, this slide here gives you the perspective that you're not alone. What you've got to understand is that I've scared you here a little bit today, and I'm sorry for that. But you know, with the progression and movement of technology, hopefully these plaintiffs' lawyers will now move on to robots that are being developed to provide medical care, and they'll leave us alone in the pain industry. So thank you for your time, your attention, and be well.
Thanks, Andy. I appreciate it. And a little fear can be a good and motivating thing. So thank you for the excellent presentation. So we've gone a little bit over tonight, and but I really appreciate the deep dive that Judd and Andy and Jen, Greg and Catherine have given us today on a variety of different topics. I'm going to suggest that we actually close it up right here, and I will, if you want to email me privately any questions you have or concerns, I know that I have a couple out there right now. I will forward them on to the relevant party just to keep things somewhat on schedule. So with that, I wish you all a very happy evening. Andy, thank you for an excellent lecture. Judd, deeply appreciate everything. Jen, fantastic job. Greg, superb. And last but not least, Catherine, wonderful to see you again, and great job. It's wonderful for everybody to get to know you. All right, guys, have a great night. Thank you all.
Thank you.